Sealing your criminal record, filing the A2J documents, going to court, and sealing. You have decided to pursue sealing your criminal record. This video will help you understand how to file your A2J documents, the rules of going to court, and sealing. If you have successfully completed the A2J sealing program, it should generate 3 documents. First, the motion to seal records with an affidavit. Second, a poverty affidavit. And third, a proposed order to seal record for the judge to consider signing upon granting a motion to seal. Your next step is to file the motion to seal with the court. The motion must be filed in the court in which the conviction was obtained or where your criminal case was heard. Before going to court to file the motion, make sure you take the completed poverty affidavit and the motion to seal affidavit to your local legal aid office or to a bank or other service with a notary public. Do not sign the affidavits until you are before the notary public. It is the job of the notary to witness your signature and notarize the documents. It is important to have the poverty affidavit completed. Courts respond to poverty affidavits in a variety of ways. Some will waive the filing fee completely. Some will reduce the filing fee. And still others will postpone the payment of the fee until the end of the case. If the court or judge refuses to waive the prepayment of the filing fee or reduces the fee to an amount you still cannot afford to pay, you may want to seek further legal assistance from your local legal aid office, a private attorney, or the Ohio Justice and Policy Center. After all 3 affidavits are notarized, make a copy of them. The poverty affidavit, the proposed order to seal the record, and 3 copies of the motion to seal affidavit. To file the motion, go to the criminal clerk of courts in the court where your case was heard. Tell the clerk that you are filing a motion to seal your criminal record. The clerk may request a filing fee. This is when you will submit the poverty affidavit, the motion to seal affidavit, and your extra copy of each of them. The clerk will timestamp with date, time, and location each of the documents and return your extra copies. Be sure to ask for your timestamp copies if you are not automatically given them. After the motion to seal and poverty affidavit is filed, also offer to give the order to seal to the clerk. Some courts may not be willing to take the order at the time of filing. If so, hang on to it and take it to court with you on the date of your record sealing hearing. When the motion to seal is filed with the court will send a copy to the prosecutor's office. The prosecutor can object to the court granting the motion to seal. This requires that the prosecutor write a brief in opposition to the motion. If that occurs, you may need to consider seeking legal advice. If you are successful in filing the motion to seal, it will be sent to a judge. The judge will then ask the probation department or the prosecutor's office to check your record. The probation officer or prosecutor will do a nationwide background check to make sure the case is finished and all fines are paid, as well as any terms of probation or other terms, including pending cases in other states. They could also request an interview with you or for additional information. When the background check is completed, probation or the prosecutor's office will make a recommendation to the judge regarding your motion to seal. If the judge agrees to the motion, a date will be set for a hearing. This may be a non-oral hearing. Non-oral meaning the judge will not need to hear anything from you, and you won't need to attend the court. The judge will decide your motion based on the paperwork you filed. Some courts will require you to attend a hearing. If this is the case, the clerk of court's office should send a notice with the date, time, and place for the hearing. If the clerk's office did not originally accept the A2J order to seal, be sure to take the order to seal document to the court and ask the judge to grant and sign the order to seal. If you do have to go to court, you should prepare for the hearing. Keep in mind that the hearing is about sealing the criminal record and not the criminal conviction case. The criminal case is over, and a judge found you guilty. Do not make arguments about your innocence or how the decision was wrong. At this point, the judge only wants to hear why your record sealing should be granted. You should be prepared to argue how you have changed your life for the better, how you have stayed out of trouble since your conviction, the negative impacts of having a criminal record, and how you meet the legal requirements to seal your criminal record. For non-convictions, you can explain how having a record is causing you problems getting a job or other obstacles that prevent you from moving on with your life. We hope this video helped you understand how to file the A2J documents, the rules of going to court, and sealing. For additional information, please visit www.ohiojpc.org.